Welcome to the Bellevue Brief, a podcast from the team at Bellevue Law, providing insights into topical workplace law and commercial disputes issues. My name is Anjali Malik, an associate at Bellevue Law, and I'm joined here with my colleague Susanne Hartigan, head of legal practice.
Thanks, Anjali. In this podcast series, the Bellevue Law team will be looking at workplace culture and professional services firms, neurodiversity and mental health at work, the impact 1 year on of the new duty to take reasonable steps to prevent sexual harassment, and also ethical redundancy processes. However, to kick off today, Anjali and I have been tasked with looking at what's being billed as the biggest shake-up of employment law in a generation, the Employment Rights Bill. We're nearly 1 year to the day when it was introduced to Parliament last year, and it proposes 28 significant areas of employment law reform. The bill is nearing the end of its parliamentary process and will likely become an act next month. It's a chunky piece of legislation, but today Anjali and I wanted to give you a heads up on 3 key areas of the bill which you need to have on your radar. One, we're going to look at big changes to unfair dismissal legislation, changes to non-disclosure and confidentiality agreements, and we'll finish off by looking at the changes to family-friendly leave.
So, in our podcast today, we'll be providing our listeners with 3 main things: a summary of the changes, an idea around the timings of those changes, and some practical steps. But Suzanne and I know that this can be quite a dry topic to discuss, and we don't want to just go through the legal reforms. So we wanted to give you also some practical tips. So hang on in there for those at the end of each section. We're recording this podcast on the 9th of October 2025. So just so our listeners can be mindful of any changes coming in. The bill is scheduled to return to the House of Lords on the 28th of October for final approval, after which it will likely receive royal assent and become an Act of Parliament.
Right, so let's get into it. So, Anjali, let's start with one of the most talked about changes, and that's to unfair dismissal. This was a Labour Party manifesto commitment, and the Labour government calls the current 2-year qualifying period arbitrary, and they've said it leaves workers waiting years for basic rights. So just taking it back a bit, can you remind us what the current position is on unfair dismissal?
Yeah, of course, Suzanne. So I'm sure many of you might know that right now employees need 2 years of continuous service before they can bring an unfair dismissal claim, unless it's automatically unfair dismissal, like for whistleblowing.
And what's the proposed change under the Employment Rights Bill?
So in short, the 2-year requirement is going, meaning unfair dismissal will become a day one right, as long as a person has started work. But of course, like anything, there are some exceptions to this, like if a job offer is withdrawn before the start date for whistleblowing or trade union reasons. I think it might also be worth mentioning here that the time limit for bringing tribunal claims is extending from 3 to 6 months, and that includes unfair dismissal claims too.
Yeah, and that extension of the tribunal limits has caused actually quite a stir.
Yeah.
But it's quite a big topic, so we have to put that to one side and address it for another time. But let's talk about this initial period of employment that's been mentioned in the bill as part of the unfair dismissal reform. Some are calling this period a statutory probationary period, although that term is not used in the bill. And just as a reminder to our listeners, we don't currently have any statutory restrictions on the lengths of probationary periods. Employers can decide this in each individual employment contract. Typically, they can be around 6 months. So can we explain a bit further about how this initial period of employment, as it's called, dovetails in with the reform to unfair dismissal legislation?
Absolutely. So during this initial period of employment, which the government has suggested to be about around 9 months, but of course this is to be confirmed, which comes as no surprise now, does it, Suzanne?
No, I mean, there's a lot in this legislation that we're waiting for the details on, as you'll hear as we go through the podcast today.
Yes, and during this initial period, employers will have access to the lighter touch dismissal process. But crucially, this won't apply to redundancies. So if an employer is making someone redundant, even during the initial period, they must still follow a full and fair dismissal process. And the lighter touch rules are for dismissals based on conduct and capability.
Yeah, I think we're anticipating that there'll be regulations that will define that lighter touch process, and we're waiting to hear what those will be.
And Suzanne, will this be a process that HR teams are familiar with, or?
I suspect some aspects of it will be. There's been an indication that this initial period of employment or statutory probationary period, in terms of the procedure, it may well involve having a meeting with an employee, and they can be accompanied to that meeting by a colleague or a trade union representative. So HR advisors will be familiar with that type of setup. What we don't know yet is how this statutory probationary period or initial period of employment, as it's called in the bill, will be officially dealt with. So it could possibly be a change to the current statutory test for unfair dismissal, and that's where you have to have a fair reason, a fair procedure, and the dismissal has to be within the range of reasonable responses. So it could be a softer touch approach to that, but we don't know at the moment. And I think it's also worth mentioning that it has been said that where there is a dismissal during the statutory probationary period, there's likely to be a cap on any compensation that is awarded to a successful employee bringing a claim in the tribunal. So it'll be lower than what's available with the current unfair dismissal damages structure. I mean, overall, this change is aimed at giving workers more protections, but it has raised concerns, especially amongst the business community. So as the bill was progressing during the parliamentary process, the House of Lords tried to change this one-day right to a 6-month qualifying period instead, but this has recently been rejected by the House of Commons.
Yeah, and unsurprisingly so when Labour has the majority in the Commons, and this was part of their manifesto commitment, wasn't it,
Yeah,
Susanne?
exactly.
Yeah.
Now, in terms of timing, we've got a bit of time. The changes are due to come into force in 2027, but we're waiting for consultations, which again were due to be published this autumn, but there could be some slip in the government timetable. And it's also worth mentioning that as at the date of us recording this podcast, we haven't received any consultation, or no consultations have been published in relation to the topics we're talking about today. So let's take a step back from looking at the actual legislation and get it back to more practical steps as to what our listeners, so what can employers and HR teams be doing now to prepare, even though the bill isn't in force yet?
Yeah, great question. Well, once someone's already in that role, you should be having a solid feedback process and any kind of performance management process throughout, and have those in place during the earlier months if possible.
That's great. I mean, clearly there is a lot of detail for the government still to flesh out with this proposal still. But as you say, employers can ready themselves now by making their recruitment and onboarding processes as robust as possible. Okay, Anjali, next up, let's talk about NDAs. This was a later addition to the Employment Rights Bill in the summer. So can you give the listeners a quick refresher on what NDAs are?
Yeah, absolutely. So NDAs, or non-disclosure agreements, are a type of confidentiality clause designed to safeguard sensitive information. And traditionally, these types of agreements have been used to protect commercially sensitive details, such as those arising during business transactions or development of new products. However, their use also extends to the employment sphere, which we'll talk about a bit more now. So within the employment context, they are most frequently used in settlement agreements, as many of you might already know. So in recent years, these agreements have been increasingly used to prevent individuals from speaking out about serious misconduct in the workplace, including harassment or discrimination.
And can you just expand on that a little bit?
Yeah, of course. So the shift in usage has raised some significant concerns, particularly regarding the potential for NDAs to silence victims and conceal inappropriate or unlawful behaviour.
Okay. And I think that's where the controversy lies.
Yeah.
So, post the Me Too movement, there's been a growing concern that NDAs are silencing victims of workplace misconduct. And by preventing the use of certain NDAs, it's hoped it will disincentivise harmful workplace behaviours and create a safer and more respectful workplace culture. And charities like Can't Buy My Silence have pushed hard for legislative reform in this area.
Absolutely. And I know there's some existing limits on NDAs. So, Suzanne, could you explain those a bit further?
Yeah,
Please?
that's right. So we do have some limits already. So we have some limits in terms of NDAs can't block, for example, whistleblowing under the Public Interest Disclosure Act. And we've seen limitations to NDAs in the higher education setting. And very recently, the Victims and Prisoners Act 2024, which came into force earlier this month, makes NDAs unenforceable against victims of crime or those who reasonably believe they've been victims of crime, and that's in relation to certain recipients. And you and I know that as solicitors, we're already bound by SRA, so the Solicitors Regulation Authority, regulatory obligations when it comes to negotiating, drafting, or advising on NDAs for our clients. But this is the first time that we're seeing broader legislative limits on NDAs. Right, so we've given a bit of background. So let's talk about what the bill is actually proposing in respect of NDAs.
Yes, of course. So it will avoid NDAs that stop workers from speaking out about harassment or discrimination, which is welcomed by many, as you might have seen some commentary on that. But whether it happened to them or someone else, and whether it was committed by a colleague or by the employer themselves. It also covers the employer's response to misconduct, such as failing to investigate complaints or engaging in any retaliatory behaviour, like issuing a negative performance review or targeting the employee with unfair treatment, which might then amount to victimisation. So, current and former workers will be protected, and this might even extend to self employed individuals and people on work experience and even trainees.
So, like, as we've mentioned, we're just waiting to hear, aren't we,
Yes,
what it will be.
running theme here.
And it's not just settlement agreements that it will apply to. It could apply to any agreement, unless, and this is the wording used in the bill, it's an accepted
Yeah,
agreement.
yeah,
And we don't have a definition of what that is yet,
yeah.
although there is an indicator that it's likely to include NDAs that are requested specifically by the worker, but we're waiting for confirmation on that. One of the points put forward by commentators for keeping the use of NDAs is that victims and witnesses may want a clean break in a scenario where they've exited their employer
Yeah.
and there's been discrimination or harassment. They just want to move on and have a clear break. So if a worker can request an NDA rather than being pressured into one by their employer as part of settlement negotiations, this would address that concern, this accepted agreement. It looks like most types of discrimination and harassment will be covered, including third-party harassment. And while victimisation isn't named, it would be covered by the bill through the employer's response to an allegation of misconduct.
Yeah.
So, point 2, do we have a timeline for when this is due to come into force?
It won't be a surprise to anyone that no, there's not, and we are still waiting. But the government has said that they'll endeavour to consult quickly, but it's not on their official ERB roadmap, which some of you might have already seen, which sets out the timeline for various reforms.
Yeah, and I think just to reinforce that roadmap, it's called Implementing the Employment Rights Bill, and it was published in July of this year. It's a really useful document to go back and look at
Yeah.
when we're expecting some more of the consultations and when the legislation is due to be implemented. Without doubt, there'll be some slip into that timetable, but I think it's really helpful for HR teams and organisations to prioritise the dates.
Absolutely.
So let's get back to our practical points. So what should employers be doing now, if anything, to prepare for this limitation on NDAs coming into force?
So, firstly, I would say if we're going to advise an employer, we would say to get familiar with proposals, do your homework as much as possible, especially HR teams that are handling exits or investigations, as well as refreshing your understanding of existing guidance from the Equality and Human Rights Commission on the use of confidentiality agreements and discrimination cases. There's also some really helpful ACAS guidance on the use of non disclosure agreements. And we can link both those documents at the end of this podcast if you're interested. Also, another thing that would be helpful for employers to be doing is to run training sessions to help the team prepare for any upcoming changes. And also, it might be a good time to start considering a refresher training more generally for your HR teams, and especially for managers who are carrying out settlement agreement negotiations.
Yeah, I think that's really useful. I just want to add 2 more points, I think. A more detailed point is I think employers can now audit their standard agreements,
Yes.
or at least pull them all together ready to be audited. So get those template settlement agreements you've used or other contract documents, check the confidentiality clauses in those policies and contracts. Look for any provisions limiting disclosure of misconduct in your organisation and consider whether they need to be changed in light of the proposals. And then stepping back, I think, from the details of it all, I think employers need to be considering if NDAs are being used regularly in their organisation to silence misconduct, then that's a broader workplace issue.
Yeah.
Employers ideally should be fostering a workplace culture of openness and inclusivity and accountability, and ideally be addressing workplace issues to reduce harassment and discrimination occurring in the first place and proactively addressing concerns when they arise.
Yes.
So review your policies like whistleblowing and harassment. Check whether they effectively support your staff's right to speak up in cases of misconduct. And are there clear reporting lines within your organisation? And then also think about the training of your managers who are asked to handle those complaints. And with NDAs potentially off the table, internal investigations will become even more important before you get to the settlement agreement stage.
Yeah.
And the reason for that is to ensure that grievances and allegations are resolved through those investigations with operational changes to those processes if necessary.
Yeah, thanks, Susanne. And I totally agree. I mean, it's clear HR teams need to proactively assess potential organisational and policy changes as the specifics of the proposal do come clear
Yeah.
over time. Do you have any final thoughts on this change, Suzanne?
Yeah, I think I just want to say one final point is, and to finish off, I think if your organisation has relied heavily on the use of NDAs to manage risk,
Yeah.
you're going to have to think very carefully going forward about how you handle that risk going forward.
Mm.
And if you're not changing your workplace culture to mitigate that risk, you could find yourself in a very difficult position. Right, last but not least, Anjali, let's talk about family-friendly leave. We're going to look at changes to paternity leave, changes to unpaid parental leave, and I'll talk a bit about the changes to bereavement leave. So kicking off, let's talk about paternity leave. What's changing?
Yeah, so eligible employees will have the right to 2 weeks paternity leave from the first day rather than how it currently is, than after 26 weeks service. And another change is that they'll also be able to take both paternity leave and pay immediately after shared parental leave and pay, which is currently not allowed.
Okay, great. And the changes to unpaid parental leave.
Yeah, so I mean, it's the same story. It will be a day one right for eligible employees instead of requiring the 1 year service as it currently stands. And the length of leave stays the same, so 18 weeks up to the child's 18th birthday. And the shift to granting both paternity leave and unpaid parental leave as a day one right brings these entitlements in line with other established family leave policies, such as maternity and adoption leave.
Okay, great. And we're expecting these changes to come into force in April 2026.
Yeah, absolutely. So let's move on now to bereavement leave.
Yep, bereavement leave. So as the law currently stands, employees who are bereaved parents can take parental bereavement leave on the death of a child under 18 or a stillbirth after 24 weeks. And there's no entitlement for anyone else, although many employers do offer a one-off entitlement. This bereavement leave is also a day one right.
So what is going to change?
So parental bereavement leave is going to be extended to become a more general bereavement leave, so dropping the word parental. And it's going to apply to a wider group of people with a relationship to the person who has died. And we're waiting for regulations to define that relationship. There's also a very welcome new provision for pregnancy loss before 24 weeks. So that would include miscarriage, ectopic pregnancy, unsuccessful IVF and more. And it will be 1 week's unpaid leave, and it'll be available to mothers and partners. Previously, those who had suffered such a loss had to take compassionate leave if provided by their employer, annual leave or unpaid time off for dependents. So as I've said, this change has been widely welcomed by campaigners and individuals and is viewed as a long overdue change in law.
But isn't the lack of pay for this period a little bit disappointing?
Yes, I mean, again, commentators have flagged this up, particularly considering it was a recommendation from the Women and Equalities Committee report on miscarriages and bereavement leave back in January.
And will the length of bereavement leave change because of the new bill?
So in terms of the current bereavement leave, that will remain unchanged where it involves the loss of a child. So that will be up to 2 weeks.
Yeah.
But for individuals who have a different qualifying relationship to the deceased, again, we're waiting to hear what that relationship is, it'll be a minimum period of 1 week's bereavement leave. And it's also leave in respect of each person who has died.
And are there any pay changes in respect to the new bereavement leave?
So in terms of pay, parental bereavement leave will continue to be payable to eligible employees where they've sadly lost a child under 18, and that's currently around £190 a week. But there is no pay provision in the bill for the wider class of bereavement leave, including for pregnancy loss before 24 weeks.
Of course, and going back to my last point, it is quite disappointing that the wider bereavement leave isn't paid.
Yes, I agree. In these difficult and stressful situations where there has been an bereavement, employees are likely to be signed off sick and then may well get sick pay. So perhaps these changes to bereavement leave aren't as significant as the government had hoped.
And what are the timings on these?
Again, we're waiting for a consultation this autumn, with implementation likely in 2027, although it's not clear when bereavement for pregnancy loss will come into effect. So, Anjali, is there anything else we want to flag to our listeners about the proposal of the changes to family-friendly rights?
Yes, so it'll be good to note that the bill will be ensuring stronger protections for pregnant employees. and those who are returning from a period of statutory leave. So we don't know what these protections will look like yet, but a consultation is due to start this autumn, and they're likely to then come into force in 2027. More generally, though, the government has announced a review of parental leave and pay, which will look at all types of leave, so including maternity, paternity, adoption, shared parental, and neonatal leave.
Okay, and drawing it back, moving away from the actual wording of the legislation and the changes, what can employers and HR teams be doing now to ready themselves for these changes to family-friendly leave?
Yes, so what can you do? So, firstly, you should be reviewing and getting your documents ready to update the family friendly policies and employment contracts to reflect all of these upcoming changes. So, including the introduction of the day one entitlements. And also, you should be ensuring that staff who are responsible for handling those leave requests, particularly, of course, those supporting bereaved employees, are trained to respond with with compassion and are aware of the forthcoming legal updates. So consider implementing some targeted training to support those employees who are going to be managing this. So finally, make sure all types of leave are accurately recorded and documented to maintain compliance and support employee wellbeing, most importantly.
Okay, great. Thanks, Anjali. I think it's also worth in organisations thinking about offering wellbeing support, like counselling or peer support to those who face bereavement.
Mm.
ACAS produced a guide a few years ago now, I think it was 2022, on managing bereavement leave in the workplace. And I think that's worth a look, even though it predates the Employment Rights Bill. As we keep saying throughout this podcast, a common theme, a lot is yet to be finalised. So we need to keep an eye out for consultations and draft regulations.
So we've covered our three topics: unfair dismissal, NDAs, family friendly leave, and it's clear that there's still plenty of detail for the government still to finalise. But Suzanne, do you have any final thoughts before we
I
finish?
do. I think just commenting on how the bill has been received, there has been mixed reception. So there's this tension between the government's mission of improving workers' lives, and that's their intention behind this bill, against the impact on businesses,
Yeah.
small businesses up to larger businesses. One thing is for sure is that it's going to entail a greater amount of work for your HR teams or those who look after HR in your organisation. So I'm going to give some closing tips for preparation. So I think firstly, resources. It's crucial for HR teams to assess now, if they haven't done already, whether they have sufficient resources to prepare for and implement the various changes as they become law. We've touched on this during our podcast, so auditing your documents. So what you
Yeah.
can be doing now before that legislation gets finalised is pull together the documents in your organisation that will need to be changed, audit them, look at policy documents, your contracts, your template settlement agreements, and you can go through those now,
Yeah.
marking up what needs to be changed and when. And then again, I like to do my broader picture, but on a broader scale, I think senior management buy-in. So getting your senior management team and your CEO on board.
Yeah.
So their awareness and active support will be essential in helping to navigate the implementation process and manage the associated time commitments, as well, I would say, as driving any cultural change through the organisation. And then to finish off, I think organisations need to think about their risk profile when it comes to the bill. So on a broad level, the bill might not present a particular difficulty to every single organisation. But for employers such as those who are used to sailing close to the wind on certain employment rights, or who, for example, use attractive exit packages tied to confidentiality provisions as a means to avoid tackling challenging internal issues, these organisations are likely to face increased financial and reputational risk because of the changes in the bill.
If you'd like to access any of the links that we've spoken about, you can find those in the blog post that accompany this podcast. Thank you all for listening, and we'll see you in the next one.